Hello, everyone. My name is Jim Malackowski. I am the co-founder and senior managing director of Ocean Tomo, and I'm thrilled to be here on IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzan and I are welcoming you to episode 160 of IP Fridays. Today's interview guest is James Malackowski, the founder of Ocean Tomo, and in my view, the first successful patent auction venue. We talk about monetization and auctioning patents, use of blockchain technology for IP and especially for licensing, the economics of data rights, and much more. But before we jump into this interview, I have news for you. The EU IPO and the EPO just released a new study, Intellectual Property Rights and Firm Performance in the European Union, on how intellectual property rights, IPRs, boost business performance in the EU. It looks at trademark rights, designs, and patents and shows that companies owning IPRs earn more revenue per employee and pay higher wages. Small and medium-sized enterprises benefit the most, with 44% increase in revenue per employee compared to the firms without IPRs. Yet, fewer than 10% of small and medium-sized enterprises use registered IPRs, showing a big untapped potential. The USPTO has unveiled a new strategy to guide the responsible development of artificial intelligence. This plan aims to clarify patent rules for AI inventions, foster public-private collaboration, and address ethical considerations like transparency and fairness. By creating clear guidelines and balanced regulations, the USPTO hopes to empower innovators and bring more AI-driven solutions to market. This strategy underscores the growing impact of AI on all industries and highlights the USPTO's commitment to shaping the future of innovation. The European Patent Office has introduced a new investor mapping initiative to strengthen Europe's innovation ecosystem. By identifying key investors, the project aims to bridge the gap between invention and market, helping inventors and businesses to find the right funding and partners. The report introduces a new metric, the Technology Investor Score, TIS, which is the proportion of companies in an investor's portfolio that have filed patent applications. This effort is designed to boost Europe's competitiveness and foster greater collaboration across industries, research institutions, and venture capital. And now let's jump into the interview with Jim Malackowski, the founder of Ocean Tomo. Today's interview guest is James Malackowski, the co-founder and senior managing director of Ocean Tomo, a part of JS Held. Before founding Ocean Tomo over 21 years ago, in 2003, Jim held several positions in the IP field. He holds a degree in business administration from Notre Dame in Indiana, and in 2022, Jim was inducted into the IP Hall of Fame. Thank you very much for being on our IP Fridays podcast, Jim.
Rolf, thank you for having me. I'm excited for the conversation.
All right. So I already mentioned that you are the founder of Ocean Tomo and you introduced the world to the first public auctions of patents, trademarks, and copyright. And in my personal recollection, it was the first patent auction site that really worked on a larger scale. I think there were some tries before that, but no one really succeeded. So tell me more about the story behind Ocean Tomo and why you think it was successful.
Sure. And Rolf, your question is actually a question within a question. Let me tell you about Ocean Tomo, and then let's talk specifically about the auction, because that itself is a really interesting story. With respect to the firm, the history of Ocean Tomo is really very similar to the history of my career. So we can trace our activities back to the Court of Appeals for the Federal Circuit in the United States changing and forming a new way of looking at intellectual property back in the 1980s. I started my career as an accountant shortly thereafter, and opportunistically happened to work on calculating damages for patent infringement litigation. And I was the first in a very small team to do that straight out of college. Because I worked on the first assignment, they gave me the second. After the second, the third, and then I was declared, a member of a small expert team as a result. So spent really the early part of my career, the first 3 years, doing nothing but looking at intellectual property in a litigated situation. In the late 1980s, a client came back and asked me to value a patent, not for the courtroom, but for a business transaction. And I can remember that day well. I literally ran down the hall to the senior partner's office talking about my first piece of revenue credit. And his answer was no. He said, it's not something that we do. It's not something that was then covered by the accounting standards, and it wasn't covered by their insurance. So a week after my 25th birthday, I left the firm. 4 of my peers came with me, and we started what was the first ever intellectual property, dispute accounting, and valuation boutique. We got lucky. That firm grew from 5 people, later partnered with private equity, and ended up selling nearly 300 people in the late 1990s.
Wow.
After that, I went to work at one of the investment houses that had invested in us and really had my eyes open as to the power and impact of intangible assets and intellectual property in particular as it relates to investment decisions. So worked on that for 2 years. And then when the non-compete was over from the sale, literally to the day, we started Ocean Tomo. And that was now in 2003, more than 20 years ago. And so my history has been an amalgamation of those experiences. Your question also asked about the auction, which is one of our favorite chapters within the firm in the early 2000s. One of my partners at that time, our vice chairman, was a very serious car collector. And as we were explaining to him the frustration we had of selling patents as a broker, he basically said to me, Jim, why do you make it so hard? Why don't you try to sell patents like Sotheby's would sell art, or like Gooding and Company sells cars? Publish a catalog, pick a date, hire an auctioneer, and let the buyers determine the market. And literally, Rolf, the room sort of smirked when we first heard that. Maybe there were some audible chuckles, but that idea stuck with me. And within 6 months, we had our first auction in San Francisco in 2006. And what's amazing about that story is we did publish a fancy catalog. We had 80 different lots of patents that were for sale. We went and hired a fancy British accented auctioneer who had great experience in both antiques and automobiles. And in that room on that day, there were more than 400 people that showed up. And when the auction started, the room, which included SIPO's former directors of patent offices around the world, a large bank of media, the room went silent. And the reason it went silent is that was the first time anybody really understood what manageable patent portfolios were worth. Because up to that point, if there was a patent sale, it wasn't disclosed. And so this was true price discovery in the market. At the end of that auction, we sold about a third of the catalog for several $1 million. I think it was $3 to $4 million. And the reaction was almost evenly split. People came up to me and congratulated us on a huge success. And then on the other side of the room, people came up to me and said, man, I'm sorry that didn't work out. And the market was really split. Shortly after the auction, we sold, I think, another $5+ million of stuff out of the catalog. But in the years that followed, we sold over $100 million on the auction floor. And it was, I think, a fundamental game-changing time in recognizing intellectual property and specifically patent value.
Yeah. So what do you think was why did 400 people come to the floor? Like, because it was just the first time, and then the other question was maybe, you said that some were disappointed and some were really excited. Some people think that patents are a lot, valued a lot, and they must be worth a lot and so on. But then really it's the market that determines the value, right? Like if you have a patent that only has a very narrow scope and not much, then there's maybe not much value to the patent, then maybe it doesn't go for a lot of money. And well, the lower threshold is always the cost of the patent, probably. But sometimes the patent maybe is not sold for much more than the cost that it already had. Or what is your opinion?
Well, I think there's really three reasons why folks attended that auction at that level. I think first and foremost, it was price discovery. They were really curious to know what these patents would sell for. Second, it was a market building networking opportunity. In many ways, whether it be the Licensing Executive Society or an ABA meeting, at that time, there were not dedicated IP brokerage and valuation conferences like there are today. So we were very much a pioneer in that space. And then the third reason is fear that one of the patents may sell, which might apply to my business, and I would miss the opportunity to acquire it for a reasonable price, and I'm going to have to explain that later. And I think that fear was augmented also in part by the fact that we are now seeing intellectual ventures and other aggregating entities being formed. And so it was that uncertainty of not wanting to miss out.
Yeah, very exciting. Yeah. And it's always interesting to see, always people ask me like, how much is my patent worth or something? I represent a lot of medium-sized companies, like maybe 500 employees, maybe 1,000 employees or something. And then they always ask me, hey, we file all these patents, how much worth are they? And then I always say, well, there's thousands of models, but what really is the worth of the patent is really what someone pays for the patent, right? And that's exactly what you determined, right?
Yeah, no, that's absolutely right. And, the way we answer that question is patents, you can think about their worth in two ways. One is, how do they help you build value in your business? And if you're able to raise capital or introduce products to the market that have unique features and maintain a proprietary position, clearly there's value there and we can determine it. And then the second is the same question, but for others. If others are using your intellectual property to capture value or to meet market needs, there is a value to them, and they should be willing to share some of that value with you in a transaction, especially a transaction that would then be a win-win opportunity.
Yeah, so I just mentioned that I'm personally representing a lot of medium-sized companies, and imagine you are the CEO of such a company. What would you tell yourself how to extract value from your research and your patents? You've talked a lot about that already, but maybe you have some, if you would be in the shoes of the CEO, what would you do?
No, great question. Let's talk about that at sort of three levels. At the highest level, plan for it. Fail to plan to fail. That motto does apply to intellectual property. And as part of that planning process, you need to proactively manage those assets. And the single element of that I advise companies is designate someone on your board of directors or your advisory board to have oversight responsibility for that IP asset and that IP function. Because just that simple designation will put it on the board agenda, will require board updates, and will elevate the role of intangibles within the business. And as your viewers might have seen from the Ocean Tomo market value study, there's been this monumental transition between tangible value and intangible value really across the world, where the intangible assets are the most important. So the board should be focused on them. Now let's go one level down. We have developed over the years somewhat of a proscriptive strategic planning process that for us has four components. First, a landscape analysis. What do you actually own, and what do your key competitors own? This reminds me of a story back, I think in the late 80s, early 90s. I had the opportunity to sit on the board of Ford Global Technologies, which at that time was the largest IP holding company, responsible for the patents of Ford, Jaguar, Aston Martin, Volvo, and Mazda at the time. And I'm probably forgetting others, but in one of my first meetings, I met with Roger May, who was the CIPO at the time, and he took me up to the corporate offices in Dearborn, Michigan. And he walked me around and he pointed to a wall of file cabinets that was 100 yards long. And he said, Jim, those are all of our patents. All of the printed files are included in those cabinets. And I said, well, Roger, that's fantastic. What can you tell me about them? And he joked and he said, frankly, I told you everything we know. Meaning there wasn't a lot of analysis and understanding of what exactly they owned and how it applied as you have today. And that lesson really stuck with me. So number one is understand the landscape. Number two is determine what are your key principles. How do you want to manage your portfolio? And we like to keep that list to be less than 10, meaning, are you willing to out-license? Are you willing to enforce? Are you willing to in-license? Are you going to manage holistically across your business or individually within divisions? Those very simple principles have to be thought through and discussed before you can really advance to the third step, which for us is knowing the landscape, knowing your principles, develop an IP plan, an IP strategic plan, which you can think of as an overlay to your general business plan. In other words, IP is not your quote unquote business, but it supports your business. So get out the business plan, the 5-year plan, and figure out how the IP assets that you own or are in your market, and according to your principles, how you want to proactively manage the plan. And then the fourth step for us is education. Don't put the plan back in the drawer. You need to share that plan not only with the board and the C-suite, but we recommend virtually everyone in the company so they understand that intellectual property, patents are easy, trade secrets are a little more nuanced, are assets of the business and need to be treated as such and then managed. And then if I look at it sort of at the final frontier level or a level of detail, what are some key considerations that we think about? They're not rocket science, but they're often not explicitly considered. So first, determine and understand what is your real proprietary competitive advantage. You have a portfolio of patents, but what do you really have that sets you apart? Second, when you think of IP management, think about it across an entire portfolio play, meaning it's not just patents, it's trade secrets, it's copyrights, it's brands, it's data. And those things need to be thought of as a collective package or portfolio that protect and support elements of the business. Third, file early. File these early comprehensive patent applications that are filed as provisionals, that put your stake in the ground, that give you time to develop the strategic assets you want. And it is heartbreaking when you see someone that has been working for years on an innovation to quote unquote perfect it, only to find out later they were 6 months late to the patent office by a early follow-on provider. And then lastly, look outside yourself. Consider strategic opportunities for IP, especially with startups. I explained to startups, okay, even if you have a great idea, the odds are that there isn't someone that's filed patents related to it before are probably pretty low. And if you file today, you're not going to get that patent protection for 3, 4, 5 years. And if you want to do it globally, it's going to be tremendously expensive. So is there a partner out there, someone who has related technology, but in a different space that would license you, perhaps an exclusive field of use license that would put you in a proprietary business immediately that you can use to leverage both discussions with investors and to support your plans? So that's generally how we think about IP strategy at a very high level.
Thank you so much. That is very helpful for the listeners, first of all, but also for my clients. So thank you. Yeah. So I want to talk about something different now. There are new technologies like blockchain, and that would be quite suitable for applications in patent licensing. That was my understanding. And maybe briefly explain to our listeners why blockchain would be suitable for licensing and why it is currently not yet employed on a larger scale.
I agree with the premise of your question. I believe that blockchain and other emerging technologies can, in fact, be helpful. I myself took the time to become certified by the AI CPA in blockchain technology just to learn. Why? I think a number of reasons. First, blockchain is suitable for multiple forms of intellectual property, be it patents, copyrights, data, trade secrets. And the reason it's suitable is because it provides an efficient and immutable way to document and package IP that's available for transfer. When you document, for example, your know-how and you wrap that into a blockchain container, everyone now can understand the metes and bounds of that technology, and importantly, the date at which it was created, and that can't change. And so it's very helpful for transacting. Because it's helpful for transacting, its sort of third reason for being, in my view, is it facilitates valuation, balance sheet recognition, and secondary trading. Licensing someone trade secrets in a normal course business or a patent in a normal course business usually ends there. But if you wrap it in blockchain data or patent rights, there's no reason that if the agreements permit, they cannot then be easily transferred to a third party. The question as to, why it hasn't been employed, I guess in part I would push back and say it is now starting to be employed. Not surprisingly, that's happening at kind of the forefront of IP recognition. And for me, that means data rights. So we are now using, and we are working with partners who explicitly have developed blockchain tools to package data, to identify it, codify it, and make it available for transactions. Ocean Tomo has also thought about blockchain as it relates to patent rights and really considering the next generation of a IP exchange following IPXI, and the notion that had we had that blockchain tool back then, I personally believe that our chances of success in developing a market for unit license rights would have been greater. And perhaps that's something we need to reconsider. And then finally, when people think of blockchain, it's not too distant to think of cryptocurrencies. And I do foresee a day when there is a blockchain-based cryptocurrency for intellectual property that comes to market. Specifically, we have thought about what we call an IP coin, where essentially you can create a cryptocurrency that is secured by explicit patents and rights in those patents, and then begin to create financing having those patents as collateral. But, we're still a ways away from that, but we continue to think about it.
I have a question following up on this. The legal framework, at least in my opinion, doesn't really seem to be up to date to really use blockchain for patent licensing contract, because in the contract, at least in Germany, I think in the US it might be similar. You still need like a signature and writing under the contract, and for the contract to be valid between the licensee and the licensor and so on. Do you think the legal framework will change to accommodate for this, or do you just use the blockchain technology for everything that follows after the signing of a license agreement, for example, or something?
I think the legal framework has to accommodate blockchain if you're going to use it. And there is a fundamental characteristic of blockchain-based patent licensing that we haven't really talked about. And that is to unitize the IP rights. So if I have a patent portfolio that you would like to use, and let's go back to Ford and assume it covers automobiles, I could create, using blockchain, 1 million unit license rights with this portfolio in mind. Meaning, if you buy one of these units, which is identified by a specific blockchain, you have the right to make X cars or trucks using this patent portfolio. And in that construct, maybe you think you're going to need 500,000 unit license rights over the next 3 years. You might buy 100,000 today because the price is attractive. And importantly, if you change your mind and you only make 70% of that 100,000, Because it's now wrapped in a blockchain, it could be recorded on your books as an asset. And assuming the agreements permit, which I presume they would, or you wouldn't go through this effort, you could then resell those blockchain patent rights to a third party and recover some of your investment, because now it is a transportable right without need for a follow-on agreement.
Yeah, excellent thought. Right. If you only want to build 70,000 cars and not 100,000 with the patent portfolio, then you can sell it to a competitor who wants to use the technology. Right.
And to the patent owner, the wonderful thing there is they get the money in advance. They sold all 100,000 to you and got paid for that some time ago. They didn't have to wait for you to make that decision or for the competitor to enter the market.
Right. Before recording the call, you told me about recent calls to consider the complete economic chain for IP licensing. What do you mean by complete economic chain for IP licensing, and what should be considered in addition to what is considered today?
To some extent, this is what we are focused on today, in that if you look at the development of any product, there's usually an original manufacturer, a component that may get integrated into a subassembly that may be integrated into a final product. And too often, the licensing process requires that the patent owner visit each of those potential licensees and specifically license them for the work that they did at each step in the value chain. That is not extremely efficient. And the litigation that results, and then the uncertainty as to who's responsible for those payments becomes murky. And it's not as if the later constituents in the value chain don't recognize the need for the rights. It's often codified in indemnity provisions within the purchase agreement, but it's not explicitly dealt with as IP. So one of the areas that we have really been focused on is the notion that upfront, there should be, at the first element of the chain, a value recognition, a royalty that's paid to that innovator that is then passed on and shared at follow-on steps in the chain in a very explicit way. And we think the market is beginning to think about that direction.
Okay. So let's switch to a different topic that is also considered to be encompassed by intellectual property. And you mentioned this in this interview already a couple of times, data rights or rights to the data. And you mentioned this also in connection with blockchain and all different kinds of contexts. So you say there is a need for a market for data rights, like an auction for data rights, or what do you think? Can you explain that?
Sure. So let's break that down and first go back to our last conversation. I do believe that blockchain can be very helpful in monetizing and making more efficient the markets for data rights for the reasons we talked about in our example. When we think about data rights, we really think about it from both a personal perspective and a business perspective. We're all familiar with the fact that each and every day we're signing on to apps and we're giving those apps permission to collect our data and to use it as a requirement for access. And there is no consideration for that. And one of the topics that we've been trying to think through is how the market could and should begin to recognize the value that individuals are providing through that process. The easier aspect, though, is to think about business rights for data, because businesses license data all the time. There's an active market, for example, to buy a mailing list for lawyers in Germany, right? That is a data set that is readily transacted and I can buy. There are other markets that have recently emerged or are emerging for other aspects of data to use within software development, to use for AI, ML, and other aspects. We think that these new tools will only make those markets more efficient, and we're excited to see that value fully realized.
Okay, so let's see what the market for data looks like in the future. I'm very excited to see this also becoming more real now. So Ocean Tomo is now part of JS Held. We didn't talk about JS Held so much so far. What is Ocean Tomo offering for the IP community besides the auctions? I always connect Ocean Tomo with the auctions because that was for me the most bright aspect of Ocean Tomo, let's say. But you have expanded your services or also offered your other services beyond auctions, right?
We have, Rolf, your question and your comment is interesting because internally we kind of joke that everybody knows Ocean Tomo for one thing. But that one thing varies depending upon who you ask. So lawyers know us for our litigation expert work, and bankruptcy trustees know us for our valuation, and you know us for auctions primarily. But to back up a second, over the 20 plus years that Ocean Tomo has been around, about every 5 years, we make a very explicit decision to look for strategic options or partners. And in the last attempt to do that, which is about 5 years ago, we decided that intellectual property is now such an important global asset, and it spreads to virtually every industry, that we would really benefit by having a global partner that is at its core an engineering consultancy, or certainly with strong engineering competence. So we set out on an explicit search for that, hired an investment banker to represent us. And when we started the process, I'll confess, I was not aware of JS Held, but they were one of the half a dozen firms that we focused on. And what we learned is that they are one of the largest consultancies around the world. They have several thousand people. And within that context, they have over 500 engineers. And those engineers are highly diversified with real market experience. So we quickly came to an agreement. And now Ocean Tomo is the IP practice of JS Held. And so as we think about what we do now, it's two-dimensional. Within our practice, we have 4 groups. We have an opinion group, which is focused on expert testimony and litigation, largely financial around determining damages, but we also provide opinions related to licensing practice and other supporting elements of a patent litigation or IP litigation process. Second for us is management consulting, which thinks strategy and valuation. So we work with startups up to Fortune 10 global companies on managing their IP strategically. Third for us is advisory, which is the investment banking group. We're a registered broker dealer, and we help both transact IP assets and raise capital for IP intensive businesses. And then lastly, technical specialty services, which is a team that crosses the rubric between patent analytics and engineering and helps with reverse engineering, evidence of use, really understanding if patents, for example, are included within the products. That's all dimension 1. Dimension 2 is when we see some technology that we're not familiar with or we need to know more about, we can now walk across the virtual hall and find an engineer who has spent their career studying that and not only understands the technology, but really understand how it operates and works in the marketplace. And that was the reason that we decided to go and merge with JS Held. And that's proven to be true. It's been very effective in the nearly 3 years since that's occurred.
Yeah, exciting. So we have been only able to scratch the surface of this broad arrangement of topics that we discussed. So what would be the best way to get in touch with you if listeners want to know more and get in more depths with you?
2 ways. One, you can email me directly at james.malackowski@jsheld.com, or go to our website and you'll see an icon pop up asking how we can help. And either way, we'll make sure that we get you to the right person. And we're always happy to spend a little time and brainstorm and see if we can assist.
Jim, thank you so much. That was a really excellent interview, and we talked about a lot of different things, and for me they were very exciting. I always wanted to talk with you, so now my wish came true. So thank you very much for being on IP Fridays.
Rolf, thank you for the opportunity and look forward to doing it again.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.